Hey, welcome back. I'm going to pick up where we left off on the last video, and we're going to move forward to the next section, which is section 4. So the changes for section 2, for section 3. So we're going to jump straight to section 4. And in section 4, we'll start off with 4.1. That's the new example on sex discrimination by perception provided here. So I think really what should happen. Let's just have a look through it. So this is basically it's on discrimination by perception. So it's direct discrimination if service providers those exercising public functions or associations treat an individual less favorably because the service provides those existing public functions or associations perceive that the individual has a protected characteristic even if they do not. So basically you're protected if you're perceived as having a protected characteristic even if you don't. However, this does not apply to the protected characteristic of pregnancy and maternity. So what they're doing here is they're giving it a couple of examples. First example, 4.1.2, people with certain Irish surnames are subjected more stringent holiday check by holiday company and then excluded from making holiday bookings because they're assumed to be Irish travellers. This is less favourable treatment because of race. And then 4.1.3, a trans is a member of an association and applies to become a treasurer, but her application is rejected. She's told by the chairman, I would say chairperson, she's told by the chairman that this is because they want a man to the role. Sorry, I thought this was supposed to be. Sorry, it's when they keep on changing the genders. It really throws me. A trans woman is a member of an association and applies to become a treasurer. Her application is rejected. She's told by the chairman that this is because they want a man to take the role on. They do not think a woman could do the job well. This is less favorable treatment because of sex. The trans woman would have a claim of direct discrimination because of her perceived sex as a woman. The fact that she's not a woman under the Equality Act 2010 would not prevent her from bringing a claim of sex discrimination. Sorry, I thought it was, when I was first reading it, I thought it was a club that restricted access based on sex. But I think I'm jumping ahead of myself here. So what we've got is a general club, and a trans woman wants to be the treasurer. She's not allowed because they don't want a woman, and so she has the opportunity to claim discrimination, regardless of the fact that the Equality Act does not consider her to be female. The current example, the rejection from the treasurer role due to explicit sexism, is based on being perceived as, and that's quite narrow. To ensure clarity, the code needs more examples illustrating sex discrimination by perceptions that are directly relevant to the common challenges trans people face and due to the code's redefinition of sex. So, for instance, a scenario that perhaps they should cover, a trans woman is directed to use the men's toilets based on her biological sex. In the men's toilets, she's harassed by other users because they perceive her as a woman. How does sex discrimination by perception protect her in this situation? And what are the service providers' responsibilities to prevent this? I think that's really important, and it is not covered here at all. In fact, the onus of the service provider to protect trans, intersex, gender non-conforming people is almost completely missing from this guidance, and really that should be the primary point. Another scenario, an example where discrimination occurs is because an individual is perceived specifically as a transgender woman. So that might involve more than just generic sexism against somebody being perceived as a woman. So how does that interact with gender reassignment discrimination? There's examples where no explicit discriminatory reason is stated, but less favorable treatment clearly stems from negative reaction to a person's perceived sex. Explain how that should be managed, because that's much more common, and a situation that trans people are more likely to be left in now. Explain the interaction between the Act's core definition of sex. So the code should clearly explain how the protection based on perceived sex as woman legally and practically interacts with the code's simultaneous assertion in chapters in chapter 2, so in 2.17 and 2.33, for the purposes of the Act, that a trans woman is a man. So how should service providers and trans individuals reconcile these two apparently contradictory legal positions when determining rights and responsibilities in terms of everyday access? The current examples focus on perception as a woman, and the code needs to clarify if this protection for perceived sex extends to situations where an individual is discriminated against because they're perceived specifically as a transgender woman, or in a scenario primarily or exclusively to be addressed as gender reassignment discrimination. The distinct application or overlap isn't made clear. There's nothing really in here about that. And they should provide actionable guidance for service providers. The code should offer clear, actionable guidance for service providers on how to proactively avoid discrimination by perception. So yeah. I mean, I don't really know exactly how they do that, but they should be providing guidance to people on that. That's definitely their remit if they're going to be implementing this guidance. For trans individuals holding a gender recognition certificate, which affirms their acquired gender for all purposes under the Gender Recognition Act 2004, the code should explain how this specific and somewhat limited protection via perceived sex offers meaningful recourse when their gender recognition certificate affirms sex simultaneously deemed irrelevant for deeming their sex under the code of the Act. So this lack of reconciliation makes the overall rights unclear. So yeah, there needs to be able to tease those issues apart and to state exactly what the value of a GRC is in this context. If anything at all, if there is no benefit, then it should state it explicitly. There is no longer a benefit to this outside of those purposes. So, okay, I'm going to move on to the next one, the next section, which is the removed reference to superseded case law. So yeah, they talk, this is a short section where they talk about the change to pregnancy and maternity. And the code should include clear guidance for service providers on how to ensure that while protection from pregnancy and maternity discrimination is afforded to trans men based on their supposed biological sex under the code, that's done in a way that respects and affirms their male gender identity and dignity. You know, there should be a statement here on that, and it should include advice on appropriate language and record keeping and avoiding unnecessary misgendering. I mean, this is going to be a really sensitive moment for a person, and a person's going to be particularly vulnerable by virtue of the fact that there are very, very few people in that position, and the media has made them something of a flashpoint. So I think that there really needs to be some sensitivity and some explicit and clear guidance in that area. The explanation needs to explicitly state how a service provider's responsibilities to avoid gender reassignment discrimination and harassment intersect with providing pregnancy and maternity services to a man under his biological sex classification. So how is a trans man, for example, protected if he's treated respectfully regarding his pregnancy needs, but is consistently misgendered and denied access to facilities with that same service? Or maybe they don't have suitable bathroom facilities for them to use that are separate from other people. I mean, it's it's quite possible that they would be prohibited from using any facilities in the kind of care facilities that they would be required to use for their maternity care. There's nothing done to tease these issues apart. They should include practical examples of how a service provider can ensure a pregnant trans man receives the necessary pregnancy-related care and protections from discrimination, to make sure that those and they should demonstrate consultation. You know, this guidance has to be informed by consultation, really. I think it's such a niche and sensitive area, and it's awful that there's been no consultation on it. But anyway, that's all I have to say on that relatively short section. We're going to move on to question 27 and changes to section 5, starting with 5.1. The new example on sex discrimination, same disadvantage, which is a particular area of discrimination law where if you are part of a class that doesn't have a claim of discrimination, but there is a class that would have a similar such claim, you can claim along with them because you were to have a disadvantage. I'll read out the example that they give. So in 5.1, it states indirect discrimination may also occur when an individual without the relevant protected characteristic experiences disadvantage alongside persons with the relevant protected characteristic, provided that a discriminatory provision, criterion, or practice puts or would put them in substantively the same disadvantage as people who share that relevant protected characteristic, such an individual may bring a claim for the same disadvantage of indirect discrimination. I don't know whether it was much clearer than what I said, but the example provided is a local council that's holding meetings on a weekday evening in an area that's considered to be unsafe for women. It discovers that fewer women attend the meeting. A woman complains this is because many women cannot come because of safety concerns, including herself. This kind of disadvantage is more likely to apply to women as a group and will amount to indirect discrimination against women. It's not direct discrimination. We're not saying women aren't allowed to come along because they're not clever enough. That would be direct discrimination and also completely untrue. Indirect discrimination, where we're making rules that disadvantage a group without necessarily meaning to, but that's the outcome. And the same protected characteristic is basically the same thing, but you're not where you wouldn't otherwise be protected. So people who don't share the same protected characteristic, but who may also feel unsafe, experience that same disadvantage. For example, a trans woman could also claim under the same disadvantage. Essentially, that's the purpose of it. Now, the example should explicitly state which protected characteristic underpins the trans woman's claim for indirect discrimination in this scenario. Because if it's intended as indirect sex discrimination, the code needs to clearly explain the legal reasoning of how a person defined as male for the equality purposes under the code can claim disadvantage based on a disadvantage shared with those defined as female sex. Crucially, it must differentiate this form or explain its relationship to a potential claim of indirect gender discrimination, which seems to more directly apply in this example. So, if it's indirect discrimination, in that case, it should be indirect discrimination in this case as well. Given that her feeling unsafe is because they present as a woman. So it really needs to address the nuance in this disadvantage. So the code should acknowledge that while a disadvantage might appear similar, the reasons for and nature of that disadvantage can differ based on protected characteristics. So, for example, a trans woman might face all the same safety as a cis woman in that area, but they might also face additional risks in terms of transphobia, homophobia, and other minority hate attacks. And the explanation needs to clarify how essentially the same disadvantage is interpreted, and if additional vulnerabilities exist due to gender reassignment. It should provide practical guidance for service providers. So it needs to provide guidance on how to proactively consider and mitigate different indirect discrimination against trans people under both sex and the gender reassignment protected characteristic. Because this example directly conflates these without a clear distinction, and it makes it really hard for providers to understand their full responsibilities under the PSED for both characteristics. PSED is public sector equality duty, is the obligations of public sector bodies in this regard. In terms of making checks that their policies and actions are consistent with things like human rights legislation and Equality Act and such. They should be performing things like equality impact assessments, so EQIA. There's another thing that doesn't appear to have been done as part of the interim update or the draft. I don't see any evidence of any impact assessments or risk assessments. Anywho, that's a matter for a different section. I'm going to move on now to question 30 and the changes in section 8. So starting off with section 8.1, this is the updated example of harassment in relation to sex. So this is unwanted conduct in relation to a relevant protected characteristic, has broad meaning and can include many situations such as those described in paragraphs below. Harassment can be related to an individual's protected characteristic, and in their example 8.3.1, a woman using gym equipment in her local leisure centre is regularly subjected to comments from male staff members such as, "Watch what you say in front of her, it's her time of the month again," and this could amount to harassment related to sex. So there's an example. And you see they give another example. The code needs to provide clearer, proactive duties for service providers to prevent foreseeable harassment against trans women that might arise from the code's own interpretation of sex. So, for example, if a policy directs trans women to male facilities, what steps must a service provider take to prevent harassment based on her being perceived as a woman in that male space, or as a trans person in that male space? And the same the other way around for trans men, and I guess non-binary people and any gender non-conforming person forced into a space that's not appropriate for them. What steps should the service provider take to prevent that foreseeable harassment for trans men in particular, actually, because I have to say the danger being a trans man walking into women's facilities, the danger of somebody watching that happen and think my daughter's in there, I'm gonna take action is it's really horrific. So they really need to provide broader examples and more than examples, including examples of harassment that are more specifically related to the experience of trans people. So a trans woman being harassed in a men's facilities. So which the code implies she should, based on biological sex, but where she's perceived as a woman, she could be, and almost certainly will be, subjected to transphobic comments. This would offer a much clearer example of generic sexism. So these things should be cleared up in examples. And the relationship between gender reassignment and harassment should be explained. The explanation should clearly distinguish between or show the overlap of harassment related to perceived sex and harassment related to gender reassignment. When would a trans woman's claim under one versus the other, or both? And the current example focuses only on perceived sex. Yeah. So here we have a trans woman using a gym. in her local leisure facilities is regularly subjected to comments from male staff. I mean, it's the same example, but just for trans women. And it says that she faces that harassment based on perceived sex. But yeah, there you go. There's no consideration again for how the GRC, which confirms her legal sex as female, would have any bearing on perceived sex or harassment. So there needs to be a consideration of the interplay there. Yeah. Okay, I think I've probably said enough on that section. I'm going to move on to question 33 and change 12.1, which may feel like we're getting quite far through here, although I'd say we're probably about halfway through, because there's more changes in section 13 than anywhere else. So there you go. So we're going to have a look at section 12 now. This is a section on a new example for women's associations. So we're going to discuss women-only associations. Now this is really it's very, very far-reaching. The consultation, the constitution of an association called the Black Jazz Players Club states that all members must have national origins in Africa or the Caribbean, despite the use of the word black in its name, because of the restrictions on membership are based on national origins and not colour. These restrictions would not be unlawful. That's, I guess, I mean, it's contextual, but it's not, I don't think there's anything directly here. 12.1.3, however, is quite relevant. Trans woman applies to join a women-only association and her application is refused. This would be lawful because the membership is based on sex and restricted to women, and under the Act, she does not share that protected characteristic. Read about the changes to blah, blah, blah. The code really needs to clarify for associations the extent to which their definition of woman and subsequent exclusion of trans women needs to be a proportionate means of achieving a legitimate aim. I'm sure we've all heard that phrase, but that clarification is not used here. But it should clarify the extent to which, because it implies that there's just a blanket exclusion. But at the same time, it uses mixed language. So this would be lawful. It doesn't suggest that this is something that they have to do, but then later that is suggested. So to what extent does it have to be a proportionate means of achieving a legitimate aim, especially considering the impact on individuals protected under gender reassignment and the blanket statement of lawfulness based solely on biological sex definition is, insufficient. So also, again, this should explicitly address GRC holders. So the example must be amended or additional examples provided to clarify that the legal rights and responsibility when a trans woman has a gender recognition certificate, or when that trans man has a gender recognition certificate, to join a women's only association, because the code needs to explain how the association's policy interacts with the GRC affirmed legal gender. So it doesn't do that. Yeah, contextualize women-only association. So there's no contextualization, because this could be like a women's-only book club. It needs to use specific examples, because women's-only association can mean a lot of things. And the difference between, a breastfeeding group and a women's book club, even like women's hockey, they have different considerations. Like, you choosing women's only association implies that all trans and intersex and potentially gender non-conforming women can be banned from a women's bird watching group for being assumed to be trans or birth sex different from whatever you're presenting as. So yeah, I mean, really define women's only association and then define the necessity under the legitimate means of a reasonable means of achieving a legitimate aim. They also need to incorporate gender reassignment discrimination. So the explanation has to clarify if an association restricts membership based on biological sex, it must still not unlawfully discriminate on the grounds of gender reassignment. So to provide an example where refusing a trans woman, even if the association defines women biologically, could be gender reassignment discrimination. You should provide an example of where that is the case. So if it's based just on prejudice against trans people, or if the biological sex criteria is not applied genuinely or proportionately, I assume this proportionate means to achieve a legitimate aim would need to include evidence, and what are the evidentiary requirements in this area, because I don't think that it's adequate to leave people to operate purely on the basis of their own stereotypes, particularly when there are very credible, well-researched and referenced reports on the inherent bias in the UK press and other forms of media. It's really important that that we emphasize evidence-based approaches throughout, and here in particular, where we're restricting access to groups, it needs to be clear that that's on the basis of evidence and not stereotypes. Okay, yeah, and guidance for associations, on how to apply the membership criteria that are lawful and non-discriminatory, because this just leaves so much unspecified. You would have no idea which way to turn with guidance like this, and just advising everybody to seek their own legal advice. I mean, if you've got, let's say you've got a book club in your local village, then you can't. How are you going to afford specialist legal advice at a time where the entire of the UK is trying to pay for specialist advice on equality and sex segregated facility legislation? It strikes me that that's absolutely unrealistic. Also, actually, reason for delaying the outcomes, because there's no way people can take advice in that kind of time frame. Well, let's move on to question 36 and change 13.1. Before we do that, though, I will take a break because it seems like a logical place. And when we come back, we're going to pick up on chapter 13, starting with updated section on competitive sports.